Right, good morning everybody. Countryside's Rights of Way panel, the 5th of August, and it's a 10 o'clock start, although we are a couple of minutes past 10 o'clock. We'll start, please, with apologies.
Good morning, Chairman. We've received apologies from Councillor Hudson.
Thank you. And can I put in apologies for Jack Abrahams as well, please? Okay, and item number 2, please. Has anyone a declaration of interest in accordance with Standing Order 16.2? No? Okay, thank you. And we'll move, actually, item 4 on the agenda, which is Wildlife Countryside Act 1981, application for footpaths from Hume Close across the field to go out to perimeter of Kiel Golf Course. I understand. Oh, apologies. Minutes from the last meeting. Agreed. Thank you to the chair of the council for pointing that out. It would be quite wrong if we did it otherwise. So item number 4, I understand, is being deferred. Is that correct? Could you just give us the reason, please?
Yes, so that matter has been deferred. Some information has come in quite last minute from the parish council. I understand that needs to be taken into consideration, so that therefore, unfortunately, the matter has had to be pulled from today's meeting and will hopefully be deferred.
Hopefully, or will be deferred?
It will be deferred.
Thank you. Right, we'll move on therefore to item number 5, which is the Wildlife and Countryside Act 1981. The proposed agreement with Staffordshire County Council under section 101 of the Local Government Act 1972, an application for the addition of an alleged public bridleway from the junction of PF6 with Six Ashes Lane to the county boundary with Shropshire, Bobbington Parish. Are you taking this one, Hannah?
Yes, that's
Thank you.
me. Thank you, Chairman. Okay, so this is in relation to a Section 53 application for the addition of a proposed bridleway in the parish of Bobbington, and also another Section 53 application that has been submitted to Shropshire County Council for the addition of a public bridleway that would be a continuation of the route applied for in the parish of Bobbington that has been made to Staffordshire County Council. So therefore the purpose of the report today is to seek the panel's authority to enter into an agreement with Shropshire County Council under section 101 of the Local Government Act 1972. So basically section 101 of the Local Government Act allows for the discharge of functions from one local authority to another. So in this case, Shropshire County Council would delegate their powers to Staffordshire County Council to determine the Section 53 applications that have been submitted both to Staffordshire County Council and to Shropshire County Council for the addition of a public bridleway, which, as I've stated, would form a continuous route across the Staffordshire-Shropshire border. So just to give a little bit of background, a Section 53 application was made to Staffordshire County Council under the Wildlife and Countryside Act for the addition of a public bridleway from the junction of Public Footpath 6 to the county boundary. An application has also been submitted to Shropshire County Council for the addition of an alleged public bridleway from Bobbington to the county road near Home Farm via Gatacre, and also for the addition of an alleged public bridleway from Public Bridleway 106 Claverley near the Rookery, which would join the alleged bridleway from Bobbington. So as the two applied for routes would form one continuous route, an anomaly would occur if Staffordshire County Council were to determine the application lodged with them in favour of the applicant, and therefore resulting in the addition of a public bridleway before Shropshire County Council were able to make a decision on the application for the addition of public bridleways on their side of the county border. We have been in correspondence with Shropshire County Council, and they have agreed in principle to delegate their powers to Staffordshire County Council in determining the part of the above mentioned continuous route which is in the county of Shropshire. Shropshire County Council will request formal delegation via their committee. Another thing to note is that Staffordshire County Council has been directed by the Secretary of State to determine the application following a directions request made by the applicant, Mr. Ray. The inspector acting on behalf of the Secretary of State acknowledged that the alleged route is a cross-border route, and therefore they stated it would be sensible for one authority to deal with the entirety of the route. We understand that a directions request has not been made by the applicant, Miss Williams, who has made the application routes on the Shropshire side of the border. So therefore, Shropshire County Council have not specifically been directed to determine the application routes made on their side of the county border. Historical evidence has been submitted in support of both applications. So to conclude, officers seek approval from the panel to enter into an agreement with Shropshire County Council to obtain delegated authority to determine the above mentioned Section 53 applications, specifically because the applied for routes form a continuous route across the Staffordshire-Shropshire border, and because Staffordshire County Council has been directed by the Secretary of State to determine the application. I'm happy to take any questions.
Thank you very much. Paul?
I think it's a wise move that we take it on. We're the people who've been directed, so we'll breach the law if we don't do it. There's no obligation on Staffordshire to rush it, on Shropshire to rush it at all. If it goes to them, then if we gave it them to deal with and they didn't, then we'd be in breach of the direction. So I think it's I'm in favour of approving it, and that we take it on board from Shropshire and work with them eventually, hand it back when it's a done deal.
Is that a proposal to accept?
Yes.
Seconded by David Smith. Anyone else want to say anything? No? Okay. So we've got a proposal and a seconder. All those in favour? Unanimous. Hannah, thank you very much for that. We now move on to item number 6, Wildlife and Countryside Act, an application for the addition of an alleged public footpath from Tenement Farm to Edgewells Farm, Ramshorn and Farley. I think this is you again, Hannah. Thank you.
Yes, thank you, Chairman. So, as stated, this is an application for the addition of a public footpath from Tenement Farm to Edgewells Farm in the parishes of Ramshorn and Farley. A copy of the line of the route can be seen at Appendix B. The application was submitted by a Mr. Ray, and it was submitted based on historical evidence. In support of the application, evidence was provided from the 1910 Finance Act, an ordnance survey map and parish survey cards for Farley and Ramshorn. So if I begin with the 1910 Finance Act material, so this material comprises of a map and field books. The Finance Act map shows a route depicted as 2 dotted lines running parallel to each other and running along the same line as the alleged route. The route runs through plot numbers 312, 582, 598, 581 and 597. The route has the annotation FP running alongside it. The field books show that plots 597, 581, 598 and 582 are all in the same ownership and are owned by Howard Winterbotham, Official Solicitor, Royal Courts of Justice. It's unclear as to who owns plot 312, as the field books state that it is the same owner as plot 302, but unfortunately details of this plot have not been provided. So the field books can identify if any deductions were made for public rights of way, which typically are shown under the sections Restrictions and Public Rights of Way of User. So for plot 312, a deduction is made in the field book of £25, but there's nothing in the actual book to indicate the nature of the public right-of-way that the deduction has been made for. When looking at plot 582, it notes that deductions are made for footpaths of £20. In plot 598, deductions are also made for footpaths of £40. Plot 581, deductions are made for public rights of way of £40, but it doesn't specifically state what the public rights of way were, although in the text of the description it does make reference to a public footpath. Plot 597 also states a deduction of £40 for public rights of way and again refers to public footpaths. The fact that a route along the line of the alleged route is shown on the map and referred to in the field books supports the existence of the way. When reviewing the field books alongside the map, it is clear that there is strong evidence that the route depicted in plots 582, 598, 581 and 597 is a public footpath, as all the entries do support that each section of the alleged route that falls into each separate plot does have the status of a public footpath. When plot 312 is considered in line with the other plots and field book entries, it is likely that as the alleged route connects and continues through the remaining plots, the whole of the alleged route, starting in the north through plot 312, is a public footpath, as it is highly unlikely that a small section of the route would not have the same status of the remainder of the route it is part of. Claims for deductions were investigated and punishments were given to those who gave false information. Therefore, it is likely that the information provided in the Finance Act material is accurate. If I move on to the Ordnance Survey map dated 1922, so the map shows two dotted lines running parallel to each other along the line of the alleged route. This also has the annotation FP running alongside it. Ordnance Survey maps do not distinguish between public and private rights of way. The fact that the map shows a route with the depiction FP supports the physical existence of the route as a footpath, but it does not provide any evidence as to whether the route is public or private. When looking at the parish survey cards for both Ramshorn and Farley, so the parish survey cards were completed as part of the 1949 Act. The parish survey card for Ramshorn FP13 shows a route referred to as Ramshorn 13 running along the same line as the alleged route. The route has the symbol FP and it is described as having been in long use for over 20 years. The parish survey card for FP38 Farley shows a route referred to as FP38 Farley running along the same line as the alleged route up to the point of the parish boundary of Ramshorn and Farley. FP38 Farley connects to FP13 Ramshorn to the south, and the majority of the alleged route is actually depicted as FP13 Ramshorn. For the parish survey card relating to FP38 Farley, it is recorded that the path starts at FP19 Ribden and the path finishes at the parish boundary with Ramshorn. It also states that FP38 is a continuation of Ramshorn FP13. So on review of the parish survey cards for FP13 Ramshorn and FP38 Farley, documentation was found relating to the objection of both of these routes to the definitive map. In relation to FP13 Ramshorn, the objection map shows that FP13 was marked as being objected to. The map also shows that the most northern part of the route, marked as FP38 Farley, was also objected to. The objections were sustained, therefore neither route appeared on the definitive map from then on. The evidence of the parish survey cards do show the existence of two routes along the line of the alleged route. And it does appear that the status of these routes were public footpaths. The intention is clear as to why the routes were added, as there appears to be evidence of long usage of the routes at the time the parish survey was carried out. It is also clear that the objector was of the opinion that the route was not accessible or used by the public at the time of the survey, despite the fact that the parish survey card did state that the route had been long used. What is not clear from the evidence is what evidence was considered at the time, such as whether any historical evidence was considered and whether the decision was made to remove the right-of-way from the definitive map. So whilst it is clear that a decision was made to remove the route from the definitive map following successful objections, it would appear that this decision was based on the way in which the route was used and who had access to it at the time of the survey. It's not evident that evidence such as the 1910 Finance Act material that has been provided by the applicant was considered on review of the objection, and therefore, as stated by the courts, further evidence can be considered when determining whether a route should be added to the definitive map, even if it has previously been removed from the map, if the new evidence provided is sufficient to show the existence of a public right-of-way, and this evidence is supportive that the route should not have been deleted from the map. So now if I just refer to evidence that has been submitted by the landowners. The owner of Ribden Farm responded to the application initially, advising that they did not consider the route to be public and they had never given anyone permission to use it. Correspondence was also received from E. Heaton and Sons, acting as agents for the owner of Ribden Farm, and they also advised that the route had not been recognised or used as a public right-of-way for the last 50 years. E. Heaton and Sons also provided correspondence and acted on behalf of the owners of Edgewells Farm and Unwin Farm. So they further advised that a Mr. Stevenson of the Farley Estate Office lodged an objection in relation to the inclusion of FP13 Ramshorn and FP38 Farley to the definitive map and statement, and that this objection was upheld, and that at the time it was agreed that there was no connecting path in the parish of Farley between Ramshorn and Farley parish boundary and any other public road or right-of-way. So this is supported by the evidence of the parish survey cards, as already discussed for FP13 Ramshorn and FP38 Farley. The tenants of Unwin Farm and Edgewells Farm also completed evidence forms advising that the route had never been used, that they were aware of, and that in places the route was blocked. On initial receipt of the application, we did also receive correspondence from Staffordshire Moorlands District Council, who advised that they had no objections to the proposal. We also received correspondence from East Staffordshire Borough Council, and they advised that they did not have any objection to the footpath, but they did ask that a letter that they had received from a landowner objecting to the application was considered. So when we look at the legal tests, the application is made under Section 53 3C1 of the Wildlife and Countryside Act 1981. Therefore, there are two tests to be considered: that of balance of probabilities, whether on the balance of probabilities the route subsists, or reasonable allegation, whether it can reasonably be alleged that the route subsists. So the Finance Act material supports the physical existence of the route and the contention that the route was a public footpath. The Ordnance Survey map also supports the existence of the route as a footpath, although it does not distinguish whether it was public or private. The parish survey cards also show that the route at one time was considered to be a public footpath. Even though the routes were not included on the definitive map, there is no evidence that the documentation provided by the applicant was considered at the time of the inquiry and therefore can be considered as part of this application. When all of the evidence is reviewed in totality, there is evidence that the alleged route physically exists as a public footpath. However, it is officers' opinion that the evidential weight of the evidence provided is not strong enough to support the route subsists based on the higher test of balance of probabilities, but it is officers' opinion that a public right-of-way with the status of footpath, which is not shown on the map and statement, can be reasonably alleged to subsist, and therefore the evidence satisfies the lower test. I'm happy to take any questions.
Hannah, thank you for that. slightly not cut and dried report. Paul, did you want to speak on it? David, no? Okay. Paul.
Under Finance Act, as Hannah says, if they made false declarations, it was an offence. So if the Finance Act says that the footpath was there, really, I think we've got to go along with it. That's the strongest evidence to show there was a footpath. So on that grounds, really, okay, on the lesser test of evidence we're going on here, I'll propose that we go along with the application and the recommendation by our officers.
Second the officer's recommendation.
Could you use your microphone?
No, I'm seconding.
No, could you use your microphone and second it?
I'm seconding.
Thank you. Excuse me. We've got a proposal and a seconder. All those in favour of the proposal? Okay. Thank you, Hannah. I think that's fairly conclusive. Right, we'll now move on, please, to item number 7, which is exclusion of the public. And I have to read out these words. That the public be excluded from the meeting for the following items of business which involve the likely disclosure of exempt information as defined in paragraphs of Part 1 of Schedule 12A, brackets as amended, of the Local Government Act 1972 indicated below. And we'll just wait for the webcast to finish before we carry on.